This presentation will cover the fundamentals of estate planning and give you information so that you can answer many of the questions that you have, that your prospective clients may have about the subject of estate planning. Beginning with this question: what is estate planning? Estate planning is educating your clients about the different ways to transfer an estate. It's explaining to them what happens in case of incapacity, i.e., they can't make decisions for themselves any longer. It's explaining to them what happens when they die, and finding out if it's important to them to transfer assets and values to the next generation, or to create and leave behind a legacy. So this is a brief list of what makes up an estate. All of the things you see here, and in addition to that, business interests, bank accounts, anything that somebody has an ownership stake in makes up or is part of their estate. The goal of estate planning, as clients relay to us when we talk with them, the reasons why someone would consider doing some estate planning, is to accomplish one of the things on this list. Stay in control of what they have, establish a legacy, have their wishes honored, leave what they have to the people or causes that are important to them, maintain their independence and privacy, spend the least amount of money, and they don't want their heirs to be intimidated by the process. How are estates transferred? Typically, one of three ways. There is no plan, they have a will, or they have a revocable living trust. No plan is referred to as dying intestate. The most famous person in recent memory to die intestate was Prince. He died in 2016, and as of 2022, the initial settlement of his estate was taking place. So dying intestate took 6 years. That might not be what your clients would hope to have happen. If someone has a will, or the legal terminology, a last will and testament, it's a legal document that conveys your wishes about what should happen to your stuff when you die. When a person dies that has a will, then a testamentary trust is established. And that's based on what their final wishes as to what should happen to their possessions when they die. So the testamentary trust does what the will said. Now, the testamentary trust is created within a will, meaning it doesn't exist until the person dies. The testamentary trust becomes active after the probate process is complete, and it allows the person who created the will to decide how and when and who receives their assets. Okay? So, what is a revocable living trust? It is a legal document that you create while you're alive. It owns your assets. You own and control the trust while alive. You, being the creator of the trust, moves their assets in and out of the trust as they want. They specify what happens to their assets after they die. It is revocable and changeable while alive, and it avoids probate. And interestingly enough, what the living trust does is this paragraph here, which is the same exact thing that the testamentary trust does. However, the difference between the revocable living trust that I create while I'm alive and the testamentary trust that is created in my will after I'm gone is that the revocable living trust avoids probate. And here you can see that illustrated. I have a will, it goes through probate, then to my heirs. I have a living trust, it avoids probate and goes directly to my heirs. What is probate? It is a legal process that occurs when a person dies that involves the validation and administration of their will. In other words, probate is a verification process. It's a title search. It's a creditor search. It's a debt settlement. And it is a legal process. Make no mistake. It is run by the courts. You need an attorney to assist you. And both the attorney and the court system takes a percentage of the assets of the estate that is being probated. Now, this diagram shows a little bit about non-probatable assets versus probatable assets. So what's the difference? Well, if something is owned by more than one person, then at death, it doesn't go to probate, it goes to the joint owner. Okay? If something has a beneficiary designation, including pay on death or transfer on death designations at a bank, then the designated beneficiary inherits that. So this would be things like a life insurance policy, an IRA, an annuity contract. Okay? And if the asset is owned by a trust, then the trust beneficiaries inherit that. So assets that have been retitled while you're alive from your name into the name of a trust, those avoid probate. But if I own something and it is part of my, and all I have is a last will and testament, then it goes through probate and my beneficiaries inherit it. If I have no will or I die intestate, then my next of kin inherit it. So if I have siblings, brothers, sisters, and kids, well, everybody gets an equal share. It would not just then go just to my children. So as you look at this, you might ask that why would anyone want to leave their assets to be probated? It's a great question that you could ask your clients as you're educating them on the different ways to transfer assets. But another question that could come up here is, doesn't this diagram mention a fourth way? Well, right here it says, does the asset have a joint owner? So you might ask that, if there's a joint owner, then you don't need a trust or a will. And that is a true statement. Typically, if it's a husband and a wife, they own property together, have joint ownership, and that is typically joint tenants with rights of survivorship. So we own it together, and the survivor gets all of those rights. Okay? And that's a pretty natural thing between a husband and a wife. But what about a single parent? Let's say dad passed away, mom is now alive, and mom is looking and says, well, if I make my son the joint owner of, let's say, my house or my brokerage accounts, then I don't have to get a trust. And that's a true statement. And I will share with you a true story. I had a friend of mine whose dad died, left the house to his wife, joint ownership. And this friend of mine, her son, moved into the house to help care for her. And he moved into the house with his wife and his children. And they built a separate residence into that house for the mom to live. She was going to live there until she died. Son gets a divorce from wife. Wife sues for one half of the son's assets, the house being one of the largest assets. She is awarded one half of the house in the divorce proceeding. The mom has to sell the house to satisfy the judgment that was part of the divorce settlement, and she now is forced to go find another place to live. That is just one of the issues of avoiding a trust and setting things up as a joint ownership with a child. So what happens when a person becomes incapacitated or dies? Well, when a person becomes incapacitated with a living trust, they typically will have a power of attorney. And that is the person who's going to make financial decisions related to their assets for them. If they have a will or no plan, well, there would probably be a court-appointed guardian who would be in charge of their financial decisions. If they had medical decisions that needed to be made, critical care decisions that needed to be made, as part of the living trust package, they would have a durable power of attorney for health care. Without that, with just a will or no plan, well, then it would be up to their medical team to make those decisions. And if it came to end of life decisions, then again, as part of their living trust package, they would have a living will. Without it, with a will or no plan, then the end of life decisions would need to be debated by a medical team or committee or something of that nature. And there are very famous court cases where this has happened, where the end of life situation has been debated and the family's wishes have been ignored. Why? Because this document wasn't in place. Well, why would the court appoint a guardian if I have a spouse or I have children? Because this provision of naming durable power of attorneys for financial assets or for healthcare decisions exists. You can do this while you are alive, while you are still in control of your faculties and not incapacitated. And the court knows that these things are available. And in their opinion is that if a person wanted to name his spouse or his child as his power of attorney, could have done that while he was alive or she was alive. But since they didn't do it, the court's assumption is that they, for some reason, didn't want that person to make decisions for them, and that is why a court-appointed guardian is put in place. So this is a scenario truly where failing to plan is planning to fail. When a person dies with a living trust, typically that can be settled in a week to 3 months, depending upon medical bills and things of that nature. And it's a very simple process that the successor trustee, the person who's in charge of your assets when you're gone, does. Very simple. With a will or no plan, it can take anywhere from 9 to 18 months, depending upon the complexity of the estate. Could probably take even longer than 18 months in some instances. And again, there is a fee that is going to be paid to the attorney as well as the court system. And here where it says settle debts and taxes, there is a final tax return that has to be submitted for anyone that passes away in this country. So that has to be done before the assets can be dispersed from the trust. How does a living trust work? Very simple. The person that sets the trust up is either the trustor, the grantor, or a trustee. They create the trust. They transfer all of their assets that are applicable assets, right? We talked about annuities not needing to go in, life insurance, IRA accounts, and that is called funding the trust. The person who creates the trust can make any changes. They get to use all of the income from the assets. They can do anything they want with the assets. They designate a successor trustee. That's the person who's in charge of everything when they're gone. If it is a husband and wife, it could be that they're both trustees. And so the successor trustee doesn't come in until both spouses have passed away. And the person who creates it designates who the beneficiaries are, when they're going to get stuff, how they're going to get stuff, names their durable power of attorney for finance and their durable power of attorney for healthcare. And they stipulate when and how the beneficiaries will receive their portion of any assets left inside the trust. So the person who creates it is in complete control until they either become incapacitated or they die. So what kind of assets go into a living trust? Well, anything that you own that does not have a beneficiary. So real estate, investment real estate, primary real estate, non-qualified accounts, stocks, bonds, Bitcoin, collectibles, business interests, bank accounts, certificates of deposit, and other things that someone owns that are not designated with a beneficiary as part of that investment. Now, there are different types of trusts. And you may say, well, why is it that all we talk about is a revocable living trust? What about an irrevocable trust, or a charitable trust, or a remainder interest trust, or a special needs trust, or a NIMCRUT, which stands for Net Income Makeup Charitable Remainder Unit Trust? Well, because all of these are pretty involved and require a lot of legal interpretation, because all of these involve giving something away that cannot be undone. A revocable living trust is something that can be changed at any time. It is the simplest of documents, and that's why you can help a client to create one of these, and that's why you should never probably try to explain any of these to your clients. So now what we're going to talk a little bit about is what goes into a trust. Okay? All of these documents here come with a living trust package, right? The trust declaration is the main trust document. A pour-over will, anything that the person has that is not part of the trust will transfer via a will into the trust and be dispersed. There is a limit in any state. See, it says enter amount in state. So you'll have to check with your state as to what the amount is. But typically smaller things, in California, I believe it's $160,000. Anything over $160,000 that isn't included in the trust would have to go through probate in order to go through the pour-over will. The durable power of attorney we've talked about, right? That to handle your financial affairs if you become incapacitated. The healthcare directorate to handle healthcare decisions if you're unable to make them or incapacitated. And then there is an abstract, which is a very short summary of the trust. And this is what you can use to present to a bank or financial institution when you are funding the trust. Okay, you have to submit something to let them know to prove that the trust is in place. And then a directive to the successor trustee. If there are specific things, I have this brooch that has been handed down into my family from great-grandmother to grandmother, and you want specific things to go to people, any of those things would be a directive that you could put as part of a trust. Some terms that you will see in a trust. A trustee or a co-trustee, those are the people who create the trust. Also grantor, trustor, but those are the people who create the trust. And if it's a husband and wife, initially they will both be co-trustees. The successor trustee is the person who is going to make decisions when, if it's husband and wife and you're co-trustees initially, when both of you are gone, that's when the successor trustee comes into play. And they are going to pay the debts, file the final tax return, and then distribute the assets of the trust. If there are minor children or grandchildren, and assets are to be dispersed at a certain age but they have not attained as of yet, then that successor trustee would manage the assets and pay any ongoing expenses until that triggering event happened. Okay. The beneficiaries are people who will inherit what's left of your estate. The key here is that everyone that does some estate planning, either they have a will or they have a trust, they're going to get a trust, right? If all you've done is a will, we already talked about it, you'll get a testamentary trust. Okay, so no matter what, you can plan now and have the trust now, and it avoids probate, or you can wait until later, and you'll get a trust if you just have a will, and your heirs will have to go through probate. There isn't a fourth option. There isn't a fifth option. There aren't any ending law changes. There isn't some executive action that's going to be issued to do away with probate court. It is a fundamental, intrinsic part of our society. There are two choices that offer some control, a living trust or a will. The difference between them, one you create now, one creates the trust for you later, one goes through probate, one avoids probate, one comes with the ancillary documents whereby you maintain control of your assets by naming who you want to speak for you if you cannot speak for yourself, and one ensures you that you will have someone appointed for you that you may not want doing the speaking for you if you are unable to speak for yourself. Again, a living trust avoids probate and has features to take care of you if you become incapacitated. A will goes through probate and only comes into play and only does anything at death. Think of a revocable living trust as a safe. When someone puts their assets inside of it, they are safe and they're under their control. Assets outside of it can be taken away from them, can be stolen, and it may not be in their control. And in the case of a trust, assets inside of the trust do not have to go through probate. Assets outside of the trust or this safe would have to go through probate, and those assets could be in jeopardy the same way as any precious possessions that you have that you failed to put inside of your safe. Abraham Lincoln said that you cannot escape the responsibility of tomorrow by evading it today. This is something that you should tell all of your clients, that this is not a situation where I can just sit on the sidelines and wait. Either they are going to become sick before they die and not be able to make decisions for themselves and not be able to have appointed someone to speak for them, or they're going to die and not have properly planned so that their heirs will have an easy, seamless process to carry out their wishes. Your role is to educate your clients about estate planning. As we've gone through today, explain the mechanics of each option. Review their assets to determine which ones would require planning, and evaluate their assets to make sure that they align with their goals and the desires for the beneficiaries who will receive them. You are not giving legal advice. You are not selling a trust. You are not using the trust to sell annuities or other products. If after you have explained to your clients what estate planning is, if you have shown them the different options available to them for estate planning, and they opt to create a revocable living trust, you can help facilitate that process by guiding them through the software that has been created by attorneys and is applicable in the state and is state specific to the state that you're working in. That is the fundamental aspects of estate planning.